Australia and New Zealand. And then last but certainly not least, the person who opened us our session today, Jody. Jody is, of course, the Vice Chair of the Hong Kong Mediation Council. Jody practiced in dispute resolution before focusing on mediation back in about 2011 and is accredited by various local and international bodies, including the HKIAC, HKMAL, International Mediation Centre. Jody's also an adjunct professor of the University of Hong Kong School of Professional and Continuing Education. So new lawyers in Hong Kong will know Jody, where she teaches mediation and negotiations. Aside from being the Vice Chair of the Mediation Council, Jody's on the Steering Committee on Mediation for the Department of Justice in Hong Kong and sits on the Mediation and Mediator Admissions Committees for the Hong Kong Law Society. Jody is a Senior Fellow of the Weinstein International Foundation and in 2016 became a Distinguished Fellow of the International Academy of Mediators and a member of its Board of Governors since 2020. That is our panel today. Let me also thank our sponsors for the event, without whose support, of course, we would be unable to bring the event. Perhaps next slide, I think. Thank you very much. These are the sponsors for the event. We thank them very much. Now, I feel like I might be, the person with the least mediation experience here, although I do think I have some to speak of. So let me just open the discussion by saying this very briefly. The pandemic is leading to change in how we work, and in fact, perhaps it's leading to or accelerating trends which were already starting to develop. But I have to say our experience, for example, here on a Zoom webinar of this nature, is kind of becoming more and more post-pandemic, virtual hearings and the like. So this panel will discuss how these changes will affect mediation in Asia and consider whether there's a best fit model in Asia. In my experience, we often confront issues around parties' willingness to open negotiations. It's often seen as a sign of weakness, but the paradox, of course, is that most commercial disputes resolve. So in a sense, the question is, how do we get to that position? And of course, as practitioners, it's incumbent upon us, and many of us are professionally bound to work with our clients and advise our clients on the merits of commercial resolution. So it's a real issue here, and it can be an issue, I think, in my experience. We get different outcomes sometimes in, if you like, different environments. And I'll give an example from my experience is in Hong Kong, sometimes I find where a kind of, if I can use the term, I don't mean to use it critically, it'll sound critical, shuttle diplomacy kind of model where the mediator acts as a shuttle diplomat sometimes. We probably see a lower success rate than mediations where, in my experience, the mediator gets involved in the merits and kind of works with the parties around the strengths and weaknesses of their case. So how does that fit with, if you like, the model for Asia Pacific? And then what's next? So with the post-COVID environment, with no doubt challenges to growth and perhaps an uptick of disputes in the post-COVID period, with working differently as we're working, what is the model for Asia? Is there a model of best fit? And to consider those issues, our panel will be kind of kicking off and kicking around some of these topics. I'm quite sure we have more content than we do time. And with all of these events, they are the better for a discussion. So we'll keep an eye on the chat function. I think everyone's been invited to share comments via chat. I'll try to keep an eye on that, and assuming my mouse works, and we'll try to add in as we speak any contributions as we go along. And the panel is also very well experienced and encouraged really to contribute where a comment is made by another panelist. But let me kick off really about, if you like, coming to the table. So I've made that observation about some reluctance sometimes to be the first mover. Is that, you know, a sign of weakness, etc.? Jeff, if I can turn to you firstly. So what are the motivations for parties in international disputes in Asia around coming to mediation, and what are the best pathways, if you like, to bring parties to the mediation room?
Yeah. Well, hello, everybody. Nice to see you. I'm down here on a very cold, early summer's day in New Zealand. So nice to see you all. And nice to see some names I recognize. But to your question, Gary, I mean, it's a good place to start. What motivates people to come to mediation? And, you know, I in my sort of ham-fisted way, I would say it's probably universal. I don't know that motivation is different in different jurisdictions or different cultures. I would have thought the answer is quite short. You know, parties in dispute want certainty, and they want it early, and they want it at proportionate cost. And I think those three touchstones are what motivate people to come to mediation. There are others, and I wish the others would have a higher profile sometimes. But certainly the studies I've read, the feedback I get from my own parties, they want certainty. It's a risk management tool. After all, mediation is simply a risk management tool. They want certainty. They want it as early as possible, not to drag on for 3 or 4 years, and they want it at a reasonable cost. And I think those are the three touchstones. I do wish that people in dispute and lawyers would also focus on the benefits of controlling their dispute. And to me, I'd like to think if I'm in conflict, that would be up there with those others I've mentioned, because rather than hand over your dispute to to a lawyer, often a judge or an arbitrator, in mediation, I can keep it within my control and have an ability to orchestrate the outcome, because I've, after all, got to agree before anything can happen. And so I think that's a real hidden benefit that people often look. And I think in COVID, that is even more important. So, and I'd be interested in others' views on this. So in COVID, I think that control is even more important, because I can decide, if I'm in a dispute, I can decide whether I elevate the commercial over the legal or the legal over the commercial. And my bet is that over COVID, because often we will have two parties, two organizations in dispute, and neither will be at fault. It's the virus. The virus is the bad guy. So I think commerciality will be elevated in the disputes that we see, because they need to get back to business. They need to preserve relationships. That's another benefit of mediation, and a motivation. Preserve relationships, get back to business, and get their cash flow running. So long answer to a fairly straightforward question. Apologies.
Well, let me add one short question and invite a short answer, Jeff, and that is, how does that play out in the more transactional context? So where parties want to preserve relationships, that's certainly an important factor. Yeah. What about the more transactional?
Yeah, and look, I think that's the absolute weakness of my argument. And in the transactional stuff, it is about cost control. It is about getting the file off the insurer's desk. It is about the funder wanting an early settlement rather than late settlement, because the metrics are better. So transactionally, and all of us mediators on a Monday morning get up and do these transactional mediations. You know, it's about a number, and they are more settlement conferences than they are mediation in that classic sense.
Right.
But you know, we've got a role to play.
Yep.
Personally, I don't like being a high-priced water boy, you know, shuttling. But sometimes that's what we've got to do, and especially in those transactional ones that you mentioned.
Yep. And Jody, I think your focus very much is on building trust in the process. So how does that play out in, if you like, where we are right now, which is bringing people into the room?
Thank you, Gary. I think in all of the mediation training courses, we've been taught that the element of trust is very important in the mediation. So I want to go deeper into this topic today, talking about trust between the mediator and the parties, and also trust between the parties themselves. So the theme of this symposium is about international commercial mediation. So I think all of the dispute resolution practitioners will agree with me that commercial disputes are often like not entirely about money. Money is only a byproduct of the disputes. Jeff mentioned just now relationship with the parties. Mediation is will be able to like be in a process, allow the parties to repair their relationship. I agree to that. But when we look at relationship of the disputing parties, there's always an element of trust. So a partnership disputes or shareholders, there's always a trust element between them. Even like between professionals, professional indemnity cases, trust by the patients or the clients towards the doctor or the lawyer. So when we look at the definition of trust, so this is an individual's belief in and willingness to act on the basis of words, actions, and decisions of the other. And in commercial disputes, there are always like business relationship, which is more like task-oriented, and parties are more focused on the achievement of goals, tasks being external to relationship. But at the same time, there's also personal relationship in some of the disputes. And I think, well, in Hong Kong, a lot of the corporations, they are operate by a family. So there's always like the family relationship, the personal relationship in the disputes itself. So in personal relationship, the primary focus on the relationship itself and the persons in there. So when a person develops trust on the other, okay, so the evaluation whether he or she can trust the other are based on like three things. So first of all is the ability. So we talk about how one, say that in my presentation, I'm going to use the term trustor here, okay? The trustor assessing the person being trusted, the trustee, all right? The assessment of the knowledge, skills, and competency. Benevolence, so whether the trustee is concerned about the trustor's welfare, the interests, the intentions, and motivations. And the third element is integrity. So it relates to whether the trustee adheres to certain principles acceptable to the trustor. So we will look at consistency with the past actions, credibility of communications, commitment to standards of fairness, congruence with of one's word and the actions. So when trust develop in a relationship and when disputes happen, all right, the trustor expectations on the trustee were unmet, trust diminish, all right, and especially like in some organizations, it will kill mutual support and information sharing within the organizations. So when there's trust violation, say a breach of a joint venture agreement or partnership agreement, so two things happen to that trustor. Cognitively, he would do an appraisal, right? What has happened? He would assign blame and evaluate the cause associated with the violation. Effectively, because of the emotional connection between these two people, so the trustor will be in a distressed state. So mediator will be very familiar with all those emotions associated with the breach of trust, anger, disappointment, and frustration. So we always have an issue of trust when we mediate disputes. So it's not just personal disputes, but commercial disputes. And diagnosing the reasons of ruined trust, I think will help two things. So first of all, what are the necessary measures for trust repair in that particular mediation for that dispute? And secondly, what the mediators could bring to the table, effective interventions leading to the repair of trust. So sometimes we can just do enough to resolve the dispute, because when we talk about trust repair, there are long-term and short-term measures for doing that. And I think for mediation purposes, sometimes as a mediator, you could just help the party to do some kind of short-term repair. So this is something that I hope well, mediators, dispute resolution practitioners will think a little bit more about the problem of trust and how we could deal with that in mediating disputes.
I'm compelled to ask a follow-on question, Jody. Thank you very much. But it occurs to me as you say this, and I'm sure we've all had experiences for good or ill around this, but allowing the parties an opportunity to get it off their chest, for or against, in terms of building trust. Are you for or against that in the process?
I would say for, but I think we need to plan that out.
Yes.
And I think in my later part of this session, I will talk a little bit more about the necessity of doing preparation and preparing the parties for the process is one of the most important things that the mediator and also the lawyer has to do.
Thank you, Jody. So Tad, let me turn to you now. Just another aspect of trust. Let's assume that trust has not got us into the room, but the court has. So under a rule of court, for example, as we have in Hong Kong, where there's a court mandated mediation. Perhaps you can tell us what the dynamic of that is in your experience and how that impacts the ability to get a resolution. Is the magic in just getting someone in the room?
Thanks, Gary, and hello to everyone. I think the question can be, it's probably answered in several ways, and it depends on which jurisdiction you come from. I'm going to assume that we're not talking about court-directed or court-mandated mediations in the form where the mediation takes place within the courtroom, or where you have a judicial officer who's mediating. I think we're going to talk about what happens in a situation where a judge or court either encourages parties towards mediation, or somewhere in the rules of court, the judge is permitted to give certain directions, which then encourages the parties to segue to mediation. Let's talk about that sort of process. In the landscape I see, and in the practice that I have, anecdotally, I think there's a discussion among counsel on when is the right time to mediate say an international commercial dispute. It's often the case, if you look at the continuum of a litigated case, if you take the mediation too early, you'll find that parties are frequently not ready. General discovery hasn't taken place. There's no real exchange of documents, and people often shy away from putting forward all their cards on the table if general discovery hasn't taken place. You'll find that even at that stage, sometimes the case theory hasn't quite been fully constructed. And you find that because of that, the BATNA is not necessarily clear to the parties. And then you swing to the other end of the continuum, where you say, what about much later then? After the affidavits of evidence in chief that we do have in the common law jurisdictions have been filed, for example, then all the information is clear. Both parties are ready to head towards a trial. Would that be a good time? And it seems that, often clients say, well, we're so fully committed and the cause are pretty much sunk by the time that we might as well see it through in many cases. So the sweet spot seems to be somewhere in the center. And speaking to some of my fellow counsel here in Singapore, I think they say perhaps after general discovery, but before you head into the process of exchange of AEICs, maybe that's a sweet spot for a litigated case. And presumably for the equivalent of an arbitrated case, it's not an apple-to-apple comparison, obviously, because arbitration has its own nuances. I'm minded to say for litigated case, after you've done the general discovery, for arbitrated cases, I'm minded to say after the statement of case and the statement of defense have been filed, because it's an upfront process, isn't it? So that's a short answer to, I think, what is in my mind, obviously no one-size-fits-all answer to the question.
Of course, yes, of course. And there's always that balance of cost and the stage at which, because as you rightly say, if you've gone too far down the track, then the view might be, well, we've come this far. Nadia, I'm going to ask you to wrap this up in a kind of context shortly, but before doing so, I'll just turn to Gary. Gary, in terms of experience in China, maybe you can share a little bit about how that's developed and the model there.
Thank you. First of all, I needed to apologize for my background. I supposed to have a
Oh, I think Gary may have frozen. Well, as they say in the classics, a technical problem. Gary looks like he's in his office, so it's not a Wi-Fi coverage thing. If Gary comes, when Gary comes back, sorry,
He's
Gary,
coming back.
you just dropped out for a minute, but apologize. Please continue.
no problem. Actually, we have two main stream of mediation in China. And, one is we call people's mediation, typically deal with small dispute amount. Mediators normally act as a semi-judges, try to guide and settle the disputes. And all the parties, especially lawyers, are expected to act very aggressively and also, have a hostile attitude. That's a very conventional Chinese mediation. But now, since a lot of Chinese companies involved in international transactions, they also become familiar with international style mediation. Actually, we can call this facilitating mediation. They also agree to choose the seat in Asian places, for example, in Hong Kong or in Singapore. And also for Chinese parties involved in international mediation, build up trust is very important. And also how to make sure this trust and the authority of the mediation and the mediation outcome itself can convince the supervisor of, for example, state-owned company senior management can accept this is a fair or it's an international standard mediation will be very important. That's my view.
That's a really fascinating point, Gary, actually, because, sometimes particularly, an officer in a state-owned enterprise or a corporate generally, this can be an experience, is sometimes less willing to, if you like, volunteer a resolution as have one imposed. How does that play out in your experience? Are things changing in China along those lines?
I think now actually people are more willing to accept international style mediation. And I think the council of them should play a very important role to educate their clients in this regard.
Thank you. Nadia, that's a really good segue into really a question for you. So the international approach, if you like, is there an Asian approach to mediation? And if not, should there be?
Thank you, Gary, and hi, everybody. So I think in past years, there has been a call, I think, for an Asian approach or an Asian model of mediation, and people like George Lim and Ian McDuff have spoken of mediation, so rather than mediation, right? But I think in part this has been a push back to sort of this US-led facilitative mediation approach, and in part also because we're decades on from when what I'll call American interest-based mediation was introduced. We're decades on, and we realize and we see now, because there's so much more professional practice going on internationally, that there is diversity, right? That mediation is not mediation, that facilitative mediation in the US looks different to facilitative mediation in Singapore and different to facilitative mediation in Germany, in my own experience, and probably also in China, given what Gary's also talked about. And so we have that sophistication, we understand those nuances. So I think if we were to think about, or this is my personal view, or to talk about an Asian model, I think we're doing ourselves in Asia a disservice. Because we're doing exactly what we're pushing back against. And we know so much more than we did 30, 40 years ago. And I think the other thing is that here today, we're focusing on international commercial mediation, right? And if you're talking about cross-border, you're probably talking about cross-cultural. What's most important, if you're going to build a model at all, is to focus on something like cultural fluency, right? The ability to read the air, right? The ability to move between different approaches and different cultures. And I think there may be some Koreans in the audience. There's a Korean word called nunchi, I think. I probably pronounced that completely incorrectly, which really talks about this, you know, what you can't see and what's not so observably on the table. And I think, you know, developing, if you like, an Asian way, which incorporates some of those factors, if anything, is what we need to be looking at.
Nadia, thank you. That sort of gets us to the room. Now we're in the room. Well, so I want to talk a little bit about the role of the mediator and how parties might go about choosing the mediator. Tat, to you firstly, and around the people issues that sort of brings into play.
Well, I mean, so, you know, Gary's selection of mediator is really a big one. I think maybe in the context of, again, of choosing a mediator for an international commercial dispute, I would say that most counsel whom I've experienced, either GC or counsel working in companies, they frequently rely on their external counsel to make that suggestion. And it's frequently, I think, the external counsel will pull out a list of people that they've either used before or they're comfortable with, and then pass it on to the general counsel for consideration. I'm not sure in my mind if general counsels frequently have their own internal list, but it seems to me that when you look at that list, it's often a very short list, and often the same players over and over again, which would sort of springboard another discussion, which is very fruitful about the sustainability of this kinds of practice, because it harks back to the data we have on arbitration, where it's the same players over and over again. Yeah. But back to the selection, I think when you look at selection process, one often in Singapore, and I suspect in parts of Asia, look to the institution to make the choice if they personally don't have a choice. And so the trustworthiness of the choices or the panelists within institutions becomes primary. I think there's a great deal of trust, at least in the Singapore and people who use the Singapore institutions, that people do trust selection of mediators picked by either Singapore Mediation Center or SIMC, that they would pick the right person for the right kind of dispute. But if you left it to counsel's own devices, I think you get a more mixed process. Anecdotally, I think at my end, I've had cases where I'd suggest to my opposing counsel that let me draw a list of a couple of people from, say, the panel of mediators at, say, SMC. You draw up a list of, say, 5 to 10, let's see where we overlap. And, among the folks who overlap, let's then pick our choice. But, that's just me. I'm not sure there's a uniform way of selection, but it's all going to be based, I think, on the, experiences with those mediators based on usage. Back to you, Gary.
Yep, thank you. And maybe, Jeff, I'll get you to comment on that in the context of, what are the factors, but also the pathways. I mean, does that impact, if you like, choice of mediator? Should it?
Yeah, look, I agree with Tat that external counsel seem to be the gatekeepers. They're the ones who will suggest, a list of 2 or 3 mediators to their client and then compare it against the counterparty's list. And in a busy jurisdiction like London, funnily enough, probably the number one factor influencing selection is availability, because over the years it's changed, and now I don't know, 95% of parties come to me with a date in mind. And if you're not available, they will move on. So that's been a change because they've got far more moving parts at their end than I have at mine. So availability is a big factor that influences selection, especially in some jurisdictions. I think, and there's been a couple of studies on this. I think the second one is around experience status. So often clients, especially, I'm gonna offend some people, but especially Americans will want a senior lawyer. So they'll be a QC or an SC in our world. And they may not be the best mediator, but they've got the best letters after their name. So that kind of status, reputation, experience is really important. And I think the third one is sector experience. So again, and I can see Tat nodding, I'd be interested in others. Over the years, subject matter expertise or sector experience has become more important for mediators than it used to be. So my generation of mediators started off, very much generous, could do a family mediation one day and a debenture, a mezzanine debt the next day. But now parties and lawyers are looking for sector experience. I always tell the story, but forgive me. About 3 or 4 years ago, I was rung up by New Zealand's Department of Conservation, who look after all our lovely, wild areas. And they said, "What do you know about hector dolphins?" And there are about 10 hector dolphins left in the world. And I said, "Look, not much." They said, "Well, we need someone who knows about hector dolphins." So I ended the telephone call by saying, "Look, my son's called Hector. Does that count?" I didn't hear from them again.
You were closest to the hole.
But that's very specialized.
Yeah. But I should say, war stories and anecdotes welcome, because that always it gives good illustration, meat to the bones of this discussion. But yes. Nadia, I think you've got a comment on this.
Thanks, Gary. Yeah, I just wanted to jump in to add on to what Jeff was saying. Because the organisation I work with, and I'd forgotten this before, which I shouldn't say I'd forgotten that. But anyway, we did a survey recently on users of international mediation. And one of the questions we asked was, what do you look for in a mediator when you use those mediators? And I can't remember it, so I've got to look it up here. But they actually put down number 1, which was really interesting, good ethics. And number 2 was dispute resolution experience. Not necessarily sector specific, but I would agree with Jeff there. And then other factors which I think are interesting for us here: efficiency. They want an efficient mediator, and I think that goes back also to what Jeff was saying. You want to get certainty and get something done. Language, cultural familiarity, and cost. So that survey, it was an international survey, but because we rolled it out the first time from Singapore, it's not a surprise that more than half of the respondents who are lawyers and their clients were from Asia. So it may have something to say about the region or not.
And Nadia, can I ask, is cost down the bottom of that list, or was that just how?
Well, I should say it's not right up the top, but the first 5 were like 1% apart or something.
Right.
They were really, really close. So here we go. Cost was 72% and good ethics was 87%. So it's not a big difference. And after that, formal qualifications, 59%, and needing a mediator from a third-party country, 53%. And if you drill down, which I won't here, and look at what the corporate clients, decision makers said, and versus what the lawyers said, there are some differences there as well. Yeah.
One would think this was rehearsed. Truly, this is not. This is a perfect segue into what I was just going to turn to Jody on, again, on trust and building that trust in the mediator, which is clearly a factor in the surveys and the input today.
Yeah, thank you, Nadia, for the information. I think from what you've just told us, it matches into some of the components of trust that parties or users look for in the mediator. I think those qualities or attributes that you just mentioned, that relates to the ability part. So when we talk about how or whether the users trust the mediator, they will look at the components of ability, their skills and knowledge, competencies and experience, reputation. And in some of the research, I think it says that people want mediator to have some candidness, flexibility, calm, humor, and also use of soft language. Another element in the trust between mediator and the parties will be about benevolence, and that relates very much to empathy. The demonstration of a mediator's empathy towards the party's interests, their desires, their motivations. And when we talk about empathy, of course, there are two particular components. The cognitive empathy, which we refer to a mediator's ability to read the thoughts, the intentions, and the desires of another person. And also the affective part, to understand the emotions of the party. And I think Nadia just mentioned ethics, and I think that relates to the integrity in the trust components. So I think that refers to two things. One is fairness. I think that's more objective because, well, when you say whether the mediator treats the parties fairly, whether they have been given enough time, that will be the objective part of the equation. But there's also a subjective part, which will be the perception of the parties as to the mediator impartiality. So I think these two key elements, impartiality and the empathy, are very important components in establishing the trust between the mediator and the parties.
And maybe a question for the panel at large on this. So I've touched on what I called shuttle diplomacy. Jeff, I think you call it a highly paid water boy, where you're running between rooms and so forth. I mean, Jody, the points you've made, indeed, of the survey, Nadia, that signals to me, and certainly it's been my experience, that an engaged mediator who is engaging with the issues, there's a fine line to draw. You don't want to be unduly judgmental, but you do want to, as a mediator, raise points which hopefully will get parties to some sort of common ground. So just for the panel at large, I mean, what are our thoughts around that, and what's the experience been? You know, where, I mean, do parties welcome that? Do they not want to hear the merits views of the mediator? How does experience sort of drive that?
Jeff, you go first.
Well, let me have a shot at that. I suppose I had a real lesson when I was talking to some internal counsel one day about this very question. How far do you want me to go? Do you want another lawyer to put their size 10 boot in this, or, you know, should a mediator be something else? And they said to me, look, we see a ball of wool, and we want the mediator to find the loose threads and just tug on them.
Right.
And Gary, you'll probably know this better than anyone, given your counsel work. But they said to me, we want you to tug on those loose threads. We may come with you, we may resist you. And I thought that was a really good way of thinking about this issue. And I've tried to keep that in mind ever since.
Yeah. Jody, your thought on that?
Yeah, 2 points. So I think number one is about time. I would think that when we talk about issues, merits, risks, etc., that would not be at the beginning of the process. I think, say, if you have a one-day mediation, that will probably be after lunch, that people are getting stuck, and they would like the mediator to jump in and then to help talking about the issues. And also something that the lawyers told me when I mediate, and this is the signal that I got, when they have a strong case, they would like to talk about legal issues right at the beginning in the morning, 9:30 a.m. And when parties do not have a strong case, they will use this kind of script. Jody, today we come here, we are to resolve the problem, and we're not here to talk about merits. Let's get on with solving the problem. So this is something that I usually pick up, and I would know when and how I will bring this up with the parties in caucus.
I can't help but say I've never experienced the weak case scenario. So, but not as a party representative anyway. I'm always utterly convinced. But in fact, I mean, that's been my experience as well. So, for example, years ago, I was a barrister in Australia, and I was mediating a professional indemnity claim. Bizarre circumstances, a fake death by the firm's principal, and as you would imagine, when you've got a principal who fakes his own death, a string of defaults and claims follow. And we had an ex-judge in Australia in those days. Mediators tended to be from that band of kind of retired judges, and he was a Court of Appeal judge. But he really did want to get into how he'd view it as a Court of Appeal judge. I found that unhelpful as a party representative, and I guess it's always a case of balancing. On the other hand, there are times, so I can see that there are some times when my case has its weaknesses, where in a way you do want the client to have their eyes opened to the relative strengths and weaknesses in what is always a dynamic environment. So I find some engagement along those lines by a mediator really helps. Whereas a mediator who does not touch the merits at all, I think sometimes we miss an opportunity. And I'll give another very quick anecdote where I went to a mediation where I was for a defendant, and it was a breach of contract claim. I was for a fund manager. So the plaintiff had a claim in damages, interest, and costs. And in the course of that mediation, which failed after a half a day, the plaintiff could not bring themselves to make a single offer, not even like judgment in full, interest and costs, and let's work down from there. So, that was not facilitative or didn't get into the merits enough, and it became a wasted outing, which is a great, shame and a waste of an opportunity. So, and I would have thought in that context, being focused or having an understanding of who you're dealing with and what their motivations are will be really critical. And in that context, I'll go back into, if you like, our walk through the process. So we've come into the room, we've selected our mediator. Now in the room, Jody, to you again, how do you develop the process? How do you build the trust in the room to develop an outcome that resolves things in a way which is, if you like, to the best extent we can, a win-win?
Well, I think just now I mentioned trust for the mediator and trust between the parties. Now it comes to trust for the process. And I wish to really underscore the importance of pre-mediation meeting. I'm not sure about how the other jurisdictions, mediators in other jurisdictions do it, because I usually see that they just meet the parties on the day. And in Hong Kong, I can see that a lot of mediators, they will make time to meet with the parties before the mediation. And this pre-mediation meeting is really important, and I always do that. And this is the time, and this is the occasion that the mediator could cement the trust right at the beginning of the process. And even though we are practicing the facilitative model, and I think the mediator for each of the cases, he should first ascertain the parties' goals in attending the mediation, why they want to come here, and then explain to the parties why a particular mode of the process is used. I can see a lot of pushbacks on people coming to a joint session. They say that we have nothing to, usually they will say, we have nothing to say, I hate the other so much. But if you are able to let the parties know how that will be relevant to their needs, the circumstances of the relationship, so that will help, the trust will grow. So just an example of a workplace conflict that I recently mediated. So one of the parties wished to understand why the other person just out of the blue started the grievance process with the HR. So making him a target for investigation. So at the pre-mediation process, this management staff, he said that, well, he wanted to know why the other person do that, why he didn't talk to me before he went to the HR. So exactly, I explained to him, the joint session will be a good occasion for you to ask that question. And so long as you remain in the same workplace, you coexist there, this kind of dialogue needs to take place. So explaining the process is something that a mediator can do to establish trust in the process. And secondly, a mediator could kind of tell the parties or anticipate how the process will likely unfold. Sharing some experiential knowledge with the parties is also helpful. So that's the beginning. And in the later stages, these kind of trust established right at the beginning will be the time that you will be using the trust to advance the process. And at the later stage, I think mediator may try to run an extra mile to help the parties to overcome challenges and impasse, and that will advance the trust element more into the process.
Jody, thank you very much. And while we've been speaking, we've had a question. CW, thank you very much for your question to the panel, which was on this issue that we sort of introduced our current topic. So, is the evaluative model suitable for Asian disputants? In Hong Kong, it's not very widely used, and that's certainly my complaint, for want of a better word, where I don't see the same success rate in some of these mediations in Hong Kong as maybe experienced elsewhere. So is it suitable for Asian disputants? And Nadia, I think you might have some thoughts around that. Nadia? Hello?
Yes,
Nadia?
thanks. I think if mediation was a move, yes, can you hear me?
Yes, we can.
You can? All right. I think there was a freeze there. Thanks. You know, I think if mediation was a movie, you know, the goodie would be facilitative mediation and the baddie would be evaluative mediation, right? Because that's often the, you know, there's this dichotomy and it's almost like this war. Are you for or against it? And I think we're asking ourselves the wrong question. I remember when I was living in Hong Kong, I think it was around 2015 or something, there was I guess a push, I think, from the couple of government departments to introduce evaluative mediation in the context of intellectual property disputes. And I gave a presentation at the time talking about 50 shades of evaluation, right? So what does evaluation mean? I'm wondering if you can still hear me?
Yes.
Yeah, we can. You're hanging a little bit,
sorry.
Nadia, but it's okay.
All right, sorry about that. Yeah, you were free. I was getting some freezing from over there. Anyway, so you know, I think that we all evaluate to some extent. You know, I think the core of mediation is that we facilitate some type of negotiation, at least in a commercial setting. And the question is, how and what do we evaluate? Because, you know, I wouldn't call myself an evaluative mediator in the, you know, in the popular sense of the word, because I'm not a legal technical expert, right? But I certainly evaluate, right? I might do something that I might call wise counsel mediation when I'm mediating in a field where I've had a lot of experience, or where people might bring me in as an insider, right? Because I'm familiar with the parties and the context. So, I think it's important to move away from both when we're mediating strict categories of law, right? Because law and economics and politics and disputes, and also to move away from this idea models are really helpful, but they're not the real world.
Right. Thank you.
My passionate speech, sorry.
There's another question from CW, which I'll pass to Gary in a moment, but any thoughts or comments on this point and Nadia's comments?
Can I maybe just weigh in to say this, that very often I think, and this is, I would call it a concern, which even experienced mediators should think about from time to time. You serve the needs of the parties, and you should be guided by what parties need. So frequently I encounter mediators who believe in their own mind that it'll be good to place their own thoughts to the table. And then if I'm a mediation advocate, I would say, don't you dare, because I will tell you as counsel when I think it's appropriate for you to put your thoughts on the table and not before, because you could scuttle what I plan to do in my mediation strategy. And so I think there's a need for that conversation to take place. I mean, certainly I think if we look at, there's not enough training, I would say, going out there, but if you look at the IMI competency for mediation advocacy, you will find right in there, use of mediators being one of the key, and knowing how to effectively communicate with the mediators prior to, during, and after the mediation session as inherent within mediation advocacy competency. So again, I say to those of us involved in this work, as a mediator, it's really not about what you think about facilitative or evaluative. It's knowing what the parties need and putting yourself in a position that's useful to the parties and being guided by counsel. Back to you, Gary.
Good comment, good thought, Tat, thank you. Well, CW, very good question around China as well, because I think any of us who've dealt with China-related litigation has had, to some extent, an experience along these lines. So the question is, if people can read it, in mainland China, is it the case that most mediations are court-led, are usually by the same judge who decides the case? Does that mean the judge tends to be overtly evaluative? Gary, what's your experience on that? You're on mute at the moment, Gary.
Sorry. Actually, my experience is that, Chinese courts already realize this problem and try to avoid this. In particular, most mediation cases happened in lowest court, like Your Majesty Court. So they have 1 month period, like a cool down period for parties before they can officially file the case with the court and enter into litigation proceedings. So during the 1 month period before the case officially accepted by the court, there will be some judges, normally one judge, different from the judge will hear the case during official litigation proceedings, conduct mediation. So I think that's good. But in like intermediate court and higher court, it could be a same judge conduct mediation and eventually make a judgment of a case. So how to avoid some, preset judgment before they really hear the case could be very challenging. And also we need to consider in China, each party bear burdens to prove their own case. We don't have full disclosure process. How to technically handle this is also a challenge to mediation in China.
Yeah, that's an excellent point actually on process or procedure. And there's a follow-up question to you, Gary, from Renee Chow, and which is when the judge is in that process of mediation, the trial judge, do they investigate? How effective are they in getting to the issues or investigating the issues?
Normally, they must get into some sort of investigation into the merits. Otherwise, it's very difficult to reach a mediation or promote a mediation. But the difficulty in Chinese, mainland China proceedings, which related to evidence production. In mainland China, due to the burden of proof, lawyers always try to hide information and get benefits from the early disclosure of facts. That's something we needed to balance. The judge found some facts and consider some merits, and also keep some neutrality and try to encourage people to realize their real intention or more important purpose to achieve during the litigation. It's already some kind of facilitating, and also the judge will try to avoid complaint from parties. In China, judge also under pressure people can complain to
Yeah.
like a disciplinary committee or something like that to allege they committed some bribery or something. So judge will also try to keep neutral for different reasons, but the result.
I think Gary's frozen again. But taking up that point, and the other thing as a party representative that strikes me in this kind of process, or med arb med, and that's not something we're going to get into in this capsule, is the dispute resolver, the arbitrator as it might be, having an insight into, if you like, client strategy, and how do you play that as a party representative. I think that's always a challenge. But we have another question, and this is great. So please do feel free to keep the questions coming. We have a pathway, but if we don't reach the end of our pathway, that's fine. If we spent time talking about issues that engage our group here. So Jonathan Rodriguez has sent a note to everyone. Biggest challenge of private mediation in India is that users have done so in the court context. So how do proponents of private commercial mediation move beyond this cultural hurdle? So this question really anticipates what we wanted to come to as a panel, which is the cultural aspects of mediation and how we work with that, and in particular the question here, how to make the profession sustainable, how to make mediation, I guess, as a process, a successful one sustainably. Any thoughts from our panel?
Let me take a shot at that, Gary. I mean, it's a great question from Jonathan, who's really one of the leaders, young leaders of mediation in India. And, I think it's a really good point. If I can just give New Zealand's very small experience, we started our mediation life off with employment mediation provided free by the state. And we then, matured and now mediate any legal dispute worth its measure really is mediated. And it was all about education. And Jonathan will know that, I'm sure, but that was a 15-year slog to educate the profession, who as we've discussed, are the gatekeepers of disputes. So it was education, period.
Jody, I think you had some thoughts about managing cultural differences.
To unmute myself. Okay.
Always good.
Thank you, Gary. Yeah, I think culture is a really great topic, and if we were to spend really go deep into it, I think we need to have another day for it. Whilst we are on the topic of trust, I wish to talk a little bit more about cultures and trust. So in my research, I find that, well, whether a person can trust the other, there are a few elements that will affect whether you are ready to trust people. So first of all is a person's personality, the belief system that that relates to the person's experience. The second element is the rules and the norms that you have been working within, like by the institutions in the society. And then thirdly is about the relationship. And I find that there's some research which shows that some of the cultures, they're more ready and willing to trust the other people. But some other cultures, that's what they call the loose cultures. And there's another group, like I think it's Asians, East and South Asians. They belong to the tight cultures. It's very difficult for them to trust people. So when we are talking about negotiation in a mediation, the tendency whether one would like to take risks, whether you would ask people questions or information about how we would resolve problem, you would try to get information. I think that affects quite a lot how people will negotiate in a mediation. So for those who are in the tight cultures, they will just rely on strategies like substantiation and the offers, and then they persuade. But for those who are in the loose cultures, they are more prone to ask questions, provide information. They're ready to like take some kind of risk. So that will affect their strategies, and that will affect their opportunities for having joint gains in the negotiation. This is something that we have been talking about in the negotiation, right? So this is something that is really interesting. So I think for lessons learned for mediator or even dispute resolution professionals, so we always have parties from different cultures. They vary in the extent of trust that they will have on the other parties or even the mediator. And that will influence the negotiation behavior, how far they're going to engage, how they would like to participate. And that varies with their tendency in trust. So this is something very interesting. And yeah, when I observe people coming from different cultures in my mediations, yeah, I find that some of them are really, they have a lot of reservation in telling the mediator a lot more about their case or about their concerns.
Right. Well, I think in fact Tat's got an anecdote. So now might be the time, Tat. I think you had a US Indonesia experience, and then I'm going to come back to the questions that have been coming in.
You know, Gary, actually, this is not that great a story, but I'll just quickly get to the nub of it. I mean, I think all of us who have mediated cross-cultural mediations, you see this, and sometimes we stereotypically assume that parties are like this. So this story really involves two parties. One's American, then NASDAQ listed company, and the other one's an Indonesian company that's fairly large, is still around. They got into negotiations, and you can see right at the word go, the American CE, the chief executive, was putting forward a rights-based negotiation model. He's basically saying, you breach your contract, you have to compensate, and then all that came right out, you know, right at the word go. And I was just fascinated. I was a young lawyer then observing what was going on. Across the table, the other company, the Indonesian company, officer just sat there and listened. And when, you know, the CE of the American company finished his speech, the Indonesian officer simply said what he wanted to say, and the negotiations came to an end. But I think what was missing from the entire dialogue was, of course, this issue of getting to, you know, your underlying interest and having a conversation that's deep in mutual respect. Long story short, at the end, parties went to arbitration. The American parties won, but so what, you know, they had a settlement agreement, went into a breach second round of arbitration, by which time the American company had spent loads of money forgetting that the subject matter equipment was based in Indonesia. So the cultural differences is such that if you're going to enforce, you got to go to Indonesia. And at the end, very sad story, the company went to Chapter 11. And the Indonesian company is still alive and kicking, probably doing very well.
Right. So cultural differences perhaps resulting in a win-lose there very much. But just a quick commentary from Winston on the reduced, if you like, use of judges in China as mediators. That's an interesting observation and something no doubt that will continue to develop. But Carolyn's asked a question, and there's a follow-on question as well from CW on this, and that is, and it you know, you make a very good point, and this is an issue I think which impacts us as practitioners in this region. We're a diverse region, culturally, legally, common law jurisdictions, civil jurisdictions, some mixtures. So where in all of this does privilege play a role? And how do we manage that? Some civil jurisdictions, of course, have concepts around confidentiality, but not around privilege. And as Gary mentioned, really disclosure and discovery are no part of the process. So let me open it to anyone who would like to contribute to this point and CW's follow-on point around that privilege in China. So Gary, that's something perhaps for you to address as well.
This is Nadia. I won't address the China point, but I'm happy to say something about the general without privilege point. So I think, yeah, I think that's absolutely right. And I think when you're mediating cross-border within Asia or between civil law and common law jurisdictions, for example, the mediation agreement becomes very, very important. I mean, it is anyway, and also the choice of applicable law. And I think the other thing to remember is that even in many common law jurisdictions, and I'm pretty sure this applies in Hong Kong and also in Singapore, and in other Asian states, there are also mediation statutes. But in Hong Kong and Singapore, without prejudice privilege is about admissibility or not of evidence from the mediation. And so there are actually statutory non-admissibility provisions, right, that actually aren't based in privilege, right, but have a different sort of legal nature, even though they're a common law country. So I think the answer is really know your mediation law when you choose the applicable law, because there certainly are, I mean, Vietnam and a whole bunch of other Asian countries now have statutory provisions on this point.
Thank you, Nadia. My own contribution to this is that very often I think we develop constructs which, touch wood, aren't tested. We do our best to be, if you like, protective, and it's a no guarantees kind of environment, I think, in many, many ways. Gary, were you able to shed some light on the issue in China and how courts deal with the idea of prejudice, privilege without prejudice?
Actually, we don't have privilege in China. And one thing is, as one of the audience already pointed out, we try to avoid judge act as a mediator and later on, act as a judge, which will help a little bit, but it's not directly related to privilege. If it is a Chinese law governed mediation, you have to be very careful when you disclose facts and evidence at mediation stage. That's my general view.
Thank you, Gary. There is one topic, so we're going to have to, I think, move shortly to a wrap up. We've got about 15 minutes of the session to go, a little over. But there's one topic in the discussion around in the room, which I think may be worth bringing out, and that is a very cryptic point that Tat has raised, which is what happens when the mediator doesn't practice what they preach? Tat, what's your thought behind that?
So this comes from a couple of people that I know who will remain unnamed to protect their innocence. One mediator actually told me, coming into mediation, he said, we're going to do, what we normally do, right? He said, and it's not the theoretical part of what we teach, but we're going to go straight out and tell parties what we think, and we're going to tell them how to resolve this problem. And the first time it happened to me, I was kind of shocked, that someone who would train and encourage parties to engage in a very facilitative model, of course, a hybrid and so on, would, throw all of that out the window when you start your, real life mediations. And his I shouldn't say his, right? But his excuse is that this is what the users want. And because if users want that, who is he to decide otherwise? And there's some truth in that. And if you peel that off, there's a lot of discussion that can go around that. But again, it's just being careful about what you, the mediator, believe to be, the model that works for the parties. And having a discussion with the mediation council, what you think, how you think you're going to run the process, and getting input from them. I think that's probably the right approach.
Thanks, Tat. And I think that raises an issue, Jeff, that you've got some thoughts around as well, which is what behaviours do successful mediators demonstrate? And I'll get you, if you don't mind, to address that thought, and then perhaps move to a wrap up. We've got a few minutes where each of the panelists can just, if you like, give us a little bit of an insight into where your view of this issue is. Mediation going forward, a model for Asia, But Jeff, firstly, just on the point around what does a good mediator look like?
Yeah, well, they're often well disguised, because a complaint I hear often is users don't know where to find mediators. And when you're in a mediation bubble and everything you do is in or around mediation, you wonder how that can be. But that is a common complaint. Where do we find good mediators? And I think the answer often is word of mouth. Some people use institutions, others query the value that an institution might add to the mediation process, but you know, everyone's got their preferences. But just picking up a point that Tat made about you know, a mediator not practicing what they preach, any mediation council on the line, I'd just like to emphasize, you know, you're in charge, and if your mediator's not behaving in the way that is helpful or the way that you expected, then please tell them. There's far too much deference to a mediator. And I think an active modern mediator is very, this is the wrong word and may not translate very well, but a modern mediator is very biddable. And we will be a chameleon. We will, you know, if you want a bit more evaluative, I'll pull those woolen strings, or you want facilitative, I'll be hands off. And I think a good mediator is able to be, I listened to the opening address for this conference by the Chief Justice of Hong Kong, and he talked about being nimble. And I think it's a lovely word. You know, mediators need to be nimble, and the market will recognize that, I think.
So just put, Gary, Jeff, I'm so sorry. Before we go to the wrap up, there's a question. Now, your comment prompts me to quote Groucho Marx, who said, "The secret to success is sincerity. If you can fake that, you've got it made."
Yes.
And it prompts the question from Michelle as to what do the panelists think about humour in use of humour in international commercial arbitration. Now, my attempt may have been weak, but what thoughts about the value of that? Is it used well? Can it be used otherwise than well?
Well, and Michelle, although I can't see him, will have a wry smile on his face. I think humour is a high wire act in a mediation, so it's dangerous. But done well, it can be the difference between a good mediation and a bad mediation, whether or not it's successful. Someone like Bill Wood, who we heard in Capsule 1, is a wonderful humorist in mediation. I would say my attempts at humour are almost always self-deprecating, because that's safer. And I've sometimes branched out from that and you know,
to your cost kind of thing.
Yes,
Yeah,
that's right.
But
I think it does have a place, especially when you arrive, and I'm arriving at a mediation tomorrow morning at 10 o'clock in Auckland. I will be able to cut the air with a knife.
Right.
And so mediation or lightness, which I would put on the spectrum, lightness of touch, lightness of attitude, you know, it's the vibe you're on, kind of stuff, is very important.
Yeah. And from my point of view, I mean, we're dealing with a variety of cultures and processes and people who are or are not familiar with a particular procedure. It's a minefield. You can be, you know, unintentionally offensive, actually, sometimes. But do other panelists have thoughts?
Hi, it's Nadia. Yeah. I just might make some closing comments. And I think, you know, following on from Jeff's comments and thinking about the future of international commercial mediation, particularly in this region, you know, I think it's important to think of international commercial mediation broadly, right? Because it's been more than one occasion where I've sat as a mediator with a commercial entity as a party, a government representative, and also for example, a local village leader of resources and a clergyman, right? And culture comes in a very sort of very strong way into a mediation like that. It's completely commercial, right? But it's also a mediation which has a space for design. And so I think there's a lot of room for designing mediation processes on a case-by-case basis. I think you can use culture to get people to buy in. You know, I remember once years and years ago talking to a paramount chief in Vanuatu, hours about, coming to a mediation. And he was gobsmacked, right, when he finally sort of had this aha moment that what we're going to do does have something to do with what we might do in the village. And then he was in, right?
Right.
And so I think while we move towards online and technology and digitization, which is all fantastic and will facilitate all sorts of mediations, we also need to remember our base and think broadly about what is this thing called international commercial mediation.
Thank you, Nadia. In no particular order other than where people are sitting on my screen, I'm going to ask Tat for some closing comments as well. We've got about 10 minutes, so you've got a good period of time just to make a few observations about our topic.
Well, Gary, thanks for this. I think what the main takeaway, which I would encourage participants to have, would be the importance of as council getting on board enough tools to be effective in mediation. It is really not the same as litigation or arbitration advocacy. And I found from my own practice that the more you pursue the knowledge that's required to be an effective advocate in mediation, I think you claim a lot of value for the clients during the mediation process. But really, that's my parting shot. There is enough, I think, discussion and literature out there talking about what makes a good mediator. But I think not enough literature and discussion on what really makes and why is it that lawyers out there should, embrace knowledge and take on more learning to be a good, if not great, mediation advocate. So it's on that parting note that I hand this back to you.
Thank you, Tat. Gary, I would invite your closing comments on the topic.
I think because the volume of Chinese economy and its increasing strength in the world economies, I think we need to educate a lot of Chinese people by various approaches, like mode mediation, like hosting seminars, and focusing on some leading in-house counsels to encourage them to write mediation clause in their contracts. And I personally very optimistic about the Chinese companies' participation in international mediation. Thank you.
Thanks, Gary. Jeff, could I invite your comments?
Look, I'll be very brief, and I'm happy to give my time to Jody, who has put all this together and has been a wonderful, wonderful resource. All I would say is, as dispute resolution professionals, we are living through a wonderfully exciting time. COVID apart, COVID's taught us so many things. We will take some of those things through into the future, and it's actually happening now, which is really exciting. And you can't see it, but my barrister's chamber is set up like NASA launching a spacecraft. I've got ring lights, I've got BBC microphones. 6 months ago, I wouldn't have dreamed of any of it, and now I just love it. So we are living in a very exciting time as dispute resolution professionals. Thank you for everyone for coming.
Thanks, Jeff. Jody, our last panelist.
Yes, thank you, Gary. So a couple of points. Jeff mentioned just now COVID. We're doing a lot more online mediations. I think for Hong Kong, meanwhile, we are doing more full online mediations, but we are also doing mediations with some kind of hybrid mode. I think recently I have quite a lot of parties from mainland China, though they can't come, but they still want, they join the mediation as a group, and then they will connect by way of Zoom or other platforms. So I think my observation is parties from Asia, mainland, Malaysia or Singapore. So I have parties coming from these jurisdictions. They still prefer some more face-to-face mediation. But at the same time, they are also open to use more of the online process. During the online process, they are more accommodating, not as harsh when they are at in-person mediations. This is something that is quite unexpected to me. And the second thing that that is connected with this online mediation process, this is a little thought of mine, and I hope to see some software or applications. I think for mediation, especially specifically designed for mediation processes. I think a lot of mediators use Zoom. That's useful, but I think there could be applications that could be more useful for mediators that would simulate quite a lot as to how real mediations look like. This is something that I'm dreaming of. And I think we need an ethical code to govern mediations conduct on an online environment. So this is something that I wish we could have in the looking forward into future. And today we talk a lot about cultural considerations. And I will anticipate, given what Gary told us just now, the facilitative model that we've been using will be more widely used or educated in Greater Bay Area in China. I have some feelings that we can do a lot more about that. And I have clients or contacts that they want more mediators from Hong Kong to promote the kind of the model of mediation that we are using here. So while we are sure of the benefits of the facilitative model, well, in managing cultural influences, I think we learn and understand cultural influences. And what are we going to do? Are we going to adopt or maintain our style, or to adapt to the other people's style? So from the recent experience that we have in Hong Kong, like start from civil justice reform up to now is like 10 years. The evolution of mediation in different jurisdictions has found its own path, and I think Hong Kong has done quite well. It's not just from the use of the process, but in terms of regulatory framework, in terms of accreditation of mediators, we are doing what is appropriate. And I think if we were to grow this model, we want to promote this kind of model, we need to look for the path which is appropriate for the market and the users. And I think we mediators and all the dispute resolution professionals in Hong Kong need to think more about that, how to understand cultural influences and try to adapt and adopt.
Thank you, Jody. And so I think to distill the core messages from the discussions we've had, our topic is international commercial mediation, a model for Asia. If that was a question, I guess the answer is kind of no, or several. There's no single model of best fit. We need to be flexible. But the key message that has just come out, for me at least, of the wrap up is, you used the word, Jody, several times, evolution. I think that's really critical. This is a process that will continue to evolve. Jeff, you've highlighted the technology aspect of it. In our, now Zoom savvy world, I mean, how many of us were using Zoom 12 months ago? In our Zoom savvy world, we're going to be doing more virtually. That actually also raises the question of cybersecurity, a whole nother topic. We talked a little bit about that. I was fortunate enough to facilitate a panel on that in the arbitration week last week here in Hong Kong. That's a topic which will no doubt impact. But I think the short answer is there is no model of best fit. There are a number of cultural and other influences, procedural influences, systemic ones, which mean that we need to stay flexible. I really appreciate everyone's input today. There's nothing, I think, more valuable than a discussion which is not just a group of talking heads, but is an engaged discussion amongst panelists and amongst all of the attendees. So may I thank you, the audience, for your contributions and questions, and it really helps engage and direct the discussion. And I'd also like to thank our panelists, Jody, Gary, Jeff, Tat, Nadia, thank you so much for your contributions, for all the work that goes into putting the contributions together and the panel together. And of course, to the Mediation Council and Academy of Mediators who are putting the sessions on, of which this was one. Really, I'm grateful to have been involved. My firm is grateful, and I appreciate everyone's input. And, you know, more than anything, being a litigator, I really like my time estimates to be right, and we are coming in right on time. So thank you very much, everyone. That's really, I regard that as the single biggest mark of success, rightly or wrongly. So thank you very much. And I think do I hand back to you, Jody, to close, or what would you like?
I think you can close the session.
Okay,
for us.
thank you. Well, as the moderator, thank you so much. Thank you everyone again, and the session is closed. I appreciate it. Enjoy the rest of the event.
Thank you.
Thank
Take
you.
care, everyone.
Thank you.
Thank you, Mr.
Bye.
Secretary.
Thank you.
Ciao, 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 Gary.
Thank you. Bye.